So I have one last question before we run out of time. The inspiration for the Sixth Amendment by the framers that you were talking about was this Walter Raleigh debacle. And I think that that is just a very different situation than what we have here. In the Raleigh case, there was a witness, Lord Cobham, and the police interrogated Cobham and tortured Cobham and finally got a confession out of Cobham and then wrote it down and made him sign it, and then he later recanted. And then they try Raleigh and they use that confession that he signed in order to, it was basically the only evidence against him. And Raleigh said, I want to be able to cross-examine Cobham, who was like right down the hall in the same tower of London. Compare that to Dr. Hines, perfectly, neutral person, and he's just a scientist creating a report. He's not a witness against Miller. He's just like a guy doing his job. I don't see how a guy doing his job is analogous to an interrogated witness. I'll just put it that way, an interrogated witness.
Well, Your Honor, the Supreme Court has construed witnesses to mean those who bear testimony, and because, hence, of course, that's why we're arguing today that the autopsy report is testimonial. I just confused myself.
You got this. So that was exactly right. And now I'm just going to ask for an example of a precedent where the court has said, here is someone who is a witness, even though that witness doesn't look a lot like the Raleigh case.
Yes, I would suggest Volkaming as an example for that. There, the analyst used that in that case that performed the blood alcohol test. Of course, was a forensic analyst, and they were considered to be a witness under the Sixth Amendment and the Confrontation Clause.
Perfect. Great job. So, tremendous job, Shelby. Definitely one of the best of the day. Who goes to the McKellar? What did Shelby do well? Now, say other questions.
I think she was really confident in answering your questions because your questions were really long. I probably would have forgot half of the things you said by the time you got done.
Like I would have stopped paying attention to you.
So I think she did a good job of grasping the actual question. She was like giving stories. I think she did a really good job paying attention.
She did do a good job. And some judges ask short questions, but some judges are asking much longer questions even than that. You'll see the transcript and it just goes on for page after page and finally get to the question. Or maybe they fail and there is no question. So I agree with that. Shelby, I really do think you did a great job. I thought that on the opening question about reliability, good job pointing out the limits of Williams, but even better job of explaining to the court why reliability is just not the test. The framers decided what would be reliable or not. And that's not a choice that we're in a position to second guess. They decided that testimony by witnesses that's not cross-examined is, by definition, not reliable. That's the choice that they made when they wrote the Confrontation Clause, and it's not for us to reconsider that. I think you could add to that reliability used to be the wrongly applied test. That was the test that comes out of Ohio v. Roberts, and the Supreme Court specifically overruled that in Crawford. So anytime you hear the word reliability, or even reliability by another name, and you're the defense, I think point out, like, that ship has sailed. The court experimented with that test for decades, and then they expressly rejected it in Crawford. Maybe the lower court agrees with that, maybe the lower court disagrees with that, but it doesn't really matter because they're a lower court. The Supreme Court's already made that decision. So good job on the reliability thing. Great job, whacking away at Dr. Adler. She wasn't there, and she can't do this, she can't do that. very effective in substance and also in terms of presentation. And then good job on, I thought a good job on the question of how this is similar to Raleigh or why the lack of similarity doesn't matter. It is a question that like drives the court a lot. I mean, you read these opinions in Wolkoming, Melendez-Diaz, Williams, all this stuff, and the Supreme Court, for better or worse, is just obsessed with this Walter Raleigh case. And so, you know, I'm not sure that your judges on Saturday will be in the weeds enough to know that, but I think that the court does care a lot, trying to figure out what this means. They look at that history. And that's not just true for Confrontation Clause, by the way. A lot of the clauses of the Bill of Rights had as their inspiration like one chapter of English history. And so the framers were like, well, that's an outrageous chapter, so we're gonna make sure that never happens again. So it's good to know that history and good to be able to say why that history is helpful to you. And then, you know, I think what you were saying in your answer to it is the Supreme Court has said that the guy doesn't have to be exactly like the Walter Raleigh case. That's why a cocaine test counts. That's why a blood alcohol test counts. And you got there with Wolkoming. I asked the follow-up question, and you knew it. You just didn't realize you knew it until I kind of led you a little bit. But good example of no matter how well you're doing, don't exhaust yourself. You know everything you need to know. So, okay. I think we have 10 minutes and 2 people, so it's gonna be fun. Taylor and Jacob. Ready when you are.
Good morning, Your Honor. May it please the court. Oh, are you answering or no? My name is Taylor Bachman, and I'm here today representing the appellant Ronald Miller. I would like to reserve 2 minutes for rebuttal.
No, Chris Grant.
I'm asking the court here today to reverse and remand the decision of the trial court due to the violation of my client's constitutional rights under the Sixth Amendment. His rights were violated due to the autopsy report satisfying the primary purpose test and the formality test. Since the autopsy report is testimonial, Dr. Adler is an insufficient replacement for Dr. Hines. The Confrontation Clause states, the accused shall have the right to be confronted with the witnesses against him. This right only applies to witnesses who provide testimony. Testimony under Crawford v. Washington was defined as the solemn declaration or affirmation made for the purpose of establishing or proving some facts. Because of this, Miller is owed the right to confront Dr. Hines.
Why don't we talk about Williams v. Illinois? Are you familiar with the case?
Yes.
Want me to explain? Okay. So
You
tell me
can
why.
explain it.
I can explain it? Okay, so in Williams v. Illinois, there were these 2 DNA tests. The government said they matched, which shows the defendant was the criminal, and they didn't call to the stand either of the people who ran the actual DNA tests. Instead, they called an expert witness. The expert witness said the DNA of this matches the DNA of this. So therefore, one DNA was from a rape kit, one DNA was from the defendant, and therefore they said the defendant is the witness. The Supreme Court said that that is okay, that there was no violation of Confrontation Clause there. So, you know, it seems to me that the surrogate witness in Williams is similar to Dr. Adler here. And if the government won in Williams, I'm wondering why the government shouldn't win here.
The surrogate witness in Williams and Dr. Adler in our present case are different. The surrogate witness in Williams did not testify as to the truth of the matter asserted and was rather providing their own opinion on the test that had been done, where in the present case, Dr. Adler was testifying to the truth of the matter asserted.
So I think that's exactly the right answer. I'm gonna ask a very hard question now. That especially since you have had evidence, this is, I know, tough to answer, but let's give it a try. What does that mean? What does it mean to testify to the truth of the matter asserted?
That, I don't know.
Alright, that's fine. Let's talk about some lower court cases. Has any lower court held the way you want us to hold, that an autopsy report is testimony?
Yes, so in the United States v. Ignatiak, they ruled in our favor. And also in Kennedy v. State, they also ruled in the favor of
Okay.
the.
And can you, the lower court cases that went the other way, do you think that they're distinguishable, or do you think they're just wrong? In other words, do you think that those facts are really different than ours? Which means maybe they were right, but you still win here. Or do you think that those lower court cases that went the other way are just flat wrong?
I think they are flat wrong. I think that there's a reason they were lower court decisions.
Okay, good. All right, let's stop there. Good job. All right, compliment. Elizabeth.
I like that at the end. I think there's a reason they're lower court decisions.
Yeah, I like that a lot. Maybe lower court judges would enjoy that too. But I like it. It's good to keep them in their place.
Yeah,
Lower court judges.
Yeah, you're just like really cool and direct and had it all together. You did not seem nervous at all, and that you had good answers. I think we maybe all need help with answering that question of like explaining what you matter sort of mean, but like.
Good. We got 5 minutes. Let's learn it.
Sounds good.
So I will take a minute and do truth and matter once Jacob's done, and then I think that everything Elizabeth said is right. I think that you kept her cool. I thought you had a very good intro, good substance, good volume, good speed. I liked the dig at lower courts at the end. I thought that was fun. I also think you chose wisely in just saying that the other courts were wrong, flat wrong, instead of trying to distinguish. If only because at this point in your preparation, you might not remember enough facts about the lower courts to distinguish them. So that was the easier answer, and so that was good. I think that your answer on truth and matter asserted was exactly right, like the difference between Williams and ours. But it is a warning to everybody, like don't use words that you don't know what they mean, because you open yourself up to a follow-up question like that. But it is a tough thing to understand, and I will spend a minute on it. So we're going to go 3 minutes with Jacob, we'll do a minute of feedback, and then we'll do a minute on truth and matter asserted. And I'll see you Saturday. All right, ready when you are.
All right. Good morning, Your Honor, and may it please the court. My name is Jacob Burdett, and I'm representing the appellant Ronald Miller. Mr. Miller's constitutional rights were violated in the lower court's ruling. I'd like to reserve 2 minutes for rebuttal.
Yes, granted.
I'm asking that the court reverse and remand the ruling of the lower court. The lower court's ruling violated Mr. Miller's Sixth Amendment constitutional rights in 2 separate ways. First, the introduction of the autopsy report without the maker's actual physical presence in court. The Confrontation Clause allows a criminal defendant the right to confront any witnesses against him in the court.
Let me interrupt this. That all sounds good, but we're short on time. Give me the precedent that you think helps you the most.
I would say in our case, Bull Cumming is very helpful.
Tell me why.
In Bull Cumming, there was a very similar case, except for instead of an autopsy report, it was a report on a blood toxicology test. And a substitute analyst was not allowed in that case, similar to our case, which I didn't get to that part explaining. I guess, can I change my answer? Sure. Okay, can I ask you to repeat the question as well, please?
Sure. Name a precedent that is helpful to your case and tell us why. And by the way, I do think Bull Cumming is a very helpful precedent to your case. So
Okay, sorry, I was skipped on to the next part of the answer. Okay, yeah, I'll stick to Bull Cumming then. Because in Bull Cumming, similar to our case, it was a substitute analyst that was admitted, and that was not allowed, and it was reversed by the courts. As well, in Bull Cumming.
should we ask a follow-up?
I would love a follow-up.
Why don't you tell us the standard of review?
De novo.
Great.
Is the
And
standard
then-
review.
And then just tell us, the last question, tell us a little bit about, just very briefly, what de novo means.
De novo, the appellate court gives no deference to the lower court, and it's basically just a fresh ruling.
Great. All right, let's stop there. Good job. Well, I think your answer on the precedent was the right answer, and I think you lost a little confidence as you were going. But look, Bull Cumming, the defense wins in Bull Cumming. It's very analogous to our case. I think there's a strong argument to be made that because the defense won in Bull Cumming, the defense should win here. And then good job knowing the standard review, and good job with the follow-up question of knowing what de novo means. So Nice job, Jacob. Okay, let's take just a minute and do truth of the matter asserted, which, deserves more than a minute, but, normally, when a witness testifies, the witness is testifying to the truth of the matter asserted, right? If I say, I saw Zach commit the murder, I'm saying that because I want the jury to know that Zach committed the murder. If I say, Zach was with me in Indiana at the time of a murder in Kansas, I'm saying that because I want the jury to know that Zach was with me in Indiana, and so therefore I have an alibi, and so therefore I'm guilty. On occasion, though, a witness will provide information not because the witness wants the jury to know the information is true. There is some other purpose to providing that information. So here's one kind of somewhat easy example. Let's say that I have written out a confession, or maybe let's just make it a will. How about that better? Okay, I've written out a will by hand. I give all my money to, not Anne. Okay, so she's not happy about that. So Anne goes to court after I'm dead. She's like, this will was not actually written by Justin. This is someone else who made this up. Justin gave all his money to Bob, but maybe Bob wrote this will and pretended it was Justin. Okay, and so then. Bob comes to the court and he's like, actually, this was Justin's handwriting, and let me prove it to you. Here is a memoir that Justin wrote, or a diary that Justin kept. Okay, and it's all written by hand. I want to admit this into evidence. And so Anne objects, and she's like, you can't admit Justin's diary into evidence. We're not here to cross-examine Justin on whether or not it's true, right? And so this is hearsay. So you can't admit this diary, it might all be wrong. And that's where Bob says, aha, we're not admitting the diary for the truth of the matter asserted. We don't really care whether the jury believes anything that's written in Justin's diary. We're just admitting Justin's diary in order for you to see what his handwriting looks like. And so since it's not being admitted for the truth of the matter asserted, there's no hearsay problem, because hearsay is there to protect against unreliable statements, right? And so that would be an example of that. You can imagine any other examples of this. Let's say I say something today, and you as my opponent want to prove that I'm lying simply by pointing out that I've contradicted myself in the past. Your point is not that what I said in the past is true. Your point is just that I've been inconsistent with what I've said. So you're bringing in that past statement not for the truth of it, but just to show that it's inconsistent with what I'm saying now. It's another example. So that's what it means to introduce something that's not for the truth of the matter asserted. In Williams, the government's argument was we're not admitting either DNA test to show that it's correct. All we care about is that the DNA test from the rape kit matches the DNA test from the defendant. And it's the match that matters, not whether either one was independently done correctly. So that's why that's one of the reasons the court allowed the evidence in Williams, because they said this DNA evidence is not being admitted for its truth. The autopsy report, definitely being admitted for its truth. Right? The only reason we care about the autopsy report is it says cause of death homicide, and the only reason the government wants to introduce it is so the jury will believe the cause of death was homicide. All right, even if you don't understand it, we're out of time.